I'm John GRAFFT, and I love Chicago real estate. Between showings, I stop in my favorite places, talk with local business owners, and bring their story to you. This is my Chicago.
Go this way?
That way you shift a little that way so I don't see the door.
Got it.
Great.
I mean, if you like the door, yeah, we can have it.
No, I trust you.
During, for me, on my side, I've maybe done one Zoom the whole time. Because it's always phone, it was always email, and I'm always in person because I have to look at the place, I have to see the place.
That's true.
So it was masked on, but nothing else had really changed.
What about a closing? I mean, do you attend?
Closings are completely different and a million times better.
But do you normally attend a closing with your...
It's a hard question
Yeah.
because...
I mean, the lawyer generally does, not
Yes.
the broker,
So,
right?
so
Yeah.
Greg's there, right? And Greg is my go-to. So the attorney is there. The attorney's not there, but usually the two attorneys are there in the closing company. And it's this 3-hour process if there's a mortgage. And you can tell that there's wasted time, and you can tell that people are doing things as it needs to be done as opposed to being prepared for it.
Sure.
Now, it's a 30-minute process. Both attorneys are remote. The closer is ready, and it's done.
Great. I've actually done one. I had it was a really strange situation. I mean, I had an elderly client who wasn't computer proficient at all, so I had to drive out to his house in the suburbs, and sit next to him. The loan officer was via Zoom. He didn't even have a smartphone, so basically we did the closing on my iPhone, and I was there while he initialed everything, and then I FedExed her back the original documents.
Yeah.
It was a refinance. That's what it was.
Okay.
Because he had to pull cash out to.
Why were you involved?
He was getting a divorce.
Okay.
And the only asset they had was equity in a home. So he had to refinance to basically cash his ex-wife out. And she was 84 and he was 78. He was
Okay.
also the oldest people I've ever divorced. So
Why do people get divorced at that age?
it's a great question. I think because to cut off inheritance, the wife had a daughter from a different relationship. So if the wife had died, the husband would inherit.
Okay.
So I guess to disinherit the husband, as well as they had marital problems.
Yeah.
I mean,
So to make sure
she
that
couldn't take it another day.
Yeah. So to make sure that the daughter would get everything she was due instead of the husband getting
Exactly.
it because the wife was older.
I mean, an estate plan would have probably accomplished, but you can't really. So exactly right.
Okay.
So
I was thinking, what a good name for this umbrella of things. Because everyone's heard of a divorce attorney, everyone's heard of divorce, but family law has a more positive spin to it, and there's many different elements. So what are the different parts of the umbrella within family law?
sure, that's a great question. So, I practice law in what's called the Domestic Relations Division. So again, it's a broad phrase, but not everyone has a traditional family. So family law can encompass, sometimes people have children when they're not married. So we used to call it paternity, now we call it parentage. So it's actually the same laws that apply in terms of child custody, child support, if you're married or not. So, you have to pay child support whether you're married or not if you have kids, and go through the legal system. So it's really an all-encompassing term. I mean, family law can encompass, same-sex marriages. I don't practice in the areas of gestational surrogacy and adoption, but that's a whole new area of law that's technically family law. I keep my practice sort of limited to divorce and parentage cases.
Okay.
But however, the practice of family law can also encompass drafting prenuptial agreements, which is when people enter into a contract before they're married to outline their respective rights and responsibilities. Sometimes people do it after they're married. One person cheats on the other person, and they say to their spouse, instead of divorcing you, I want you to sign a contract saying that if it happens again, you owe me $50,000. It can basically say whatever you want.
Interesting.
The difference is you just enter into a contract after you're married. So therefore, it's a postnup instead of a prenuptial agreement.
What things can you outline in that postnuptial?
You can pretty much outline everything that is legal.
Mm-hmm.
So you cannot contract, you can't, if it's against public policy, so you can't put a cap on child support, for instance.
Okay.
Well, I'm sorry, you can't waive child support, for instance, because that's the right of the child. You could put a cap on it. You could say that we have to go on X amount of dates per month. And if
Interesting.
you don't honor it, then, we're going to get divorced, or that there's a financial penalty. You just can't, you can't contract for murder or something illegal.
It seems to remove all the romanticism for something like you just described, like, okay, we have to do X amount of dates per month. But on the flip side of it, when you're talking about someone who maybe they were unloyal and they stepped out of their marriage, and then the husband or wife wants to keep it on track, the spouse, so they say, okay, this is our chance, like this is the agreement we're coming to so we can move forward. And they want to make sure that it happens the way they do. How many times do you create something like that, or how often is this occurrence?
I get about one per year,
Okay.
I would say. Most often, someone comes into my office and they want a contract. I'd say 9 out of 10 times a classic prenuptial agreement.
Mhm.
1 out of those 10 times is a postnuptial agreement.
Okay.
The one that I recently did, the parties had been separated since 2009. I represented the husband who wanted to buy a home. They were technically still married. He's to this day is technically still married. So what he wanted to do is, when they do eventually get divorced, which are their plans, he wants to make sure that that home he purchased does not go into a marital pot. So he put a $100,000 down payment on that house. So we had to have a postnuptial agreement saying, his wife is entitled to a corresponding $100,000 cash payment in consideration for waiving his interest in that property. So even though they've been separated for 10 years, the law says that any property earned or acquired during the marriage is marital property. So in order to basically cement to avoid his wife making a claim on that house, the parties had a postnuptial agreement, which basically built the bridge until we can finalize their divorce, which we're in the process of finalizing now.
If someone's been separated for a decade, why are they putting off the divorce? What are the reasons that people have for that?
It's an excellent question. So, people can be living in the same house and be legally separated. Legally separated just means, when they've last lived as man and wife. Some people interpret that as, when people sleep in the same bed. Other people interpret that as when they've last had sexual intercourse. But for a whole variety of reasons, people stay married despite being in legal separation. One is religion. Some religions prohibit divorces, so it's a way to stay married but not get divorced. Back in the day, insurance companies used to honor judgments of legal separation. So if 2 spouses are separated and one person has a chronic illness, the second they get divorced, they can only go on their former spouse's insurance plan, I'm sure you've heard of COBRA,
Yeah.
for up to 36 months after the divorce. So if you're a 60-year-old woman and you have multiple sclerosis, if you get divorced, you only get health insurance for 3 years, unless you want to pay between $500 and $700 a month on the open market. Back in the day, people used to enter into a judgment of legal separation so that in this example, wife could still stay on the husband's insurance because they're still legally married.
So the spouse has some empathy for the situation.
Yes.
Doesn't want to rob them of that. There's no ill will, or maybe not ill will to that type of extent where you're going to stop someone's health care.
That's right.
Okay. What are some
That's
other
right.
reasons?
So, those are the 2 main ones.
Those make sense to me. I can
Otherwise,
see social stigma too. I mean,
That's right.
That's lessening, but still, back to the religion and communities that are more tight knit, people are putting on a front for their friends and family, and they don't want to separate that.
And you can
I know
still file
people
a
like
joint
that.
tax return if you're.
That's a big one.
Right.
Yeah.
So if someone has investment, they don't want to lose the benefit of filing jointly. And, like we said, the religious reasons. And some people just, don't want to disclaim their right to inherit. So as we were discussing earlier, if you die and you're married, your spouse can inherit from you. So some people just want to live their separate lives, but if you get divorced, that cuts off the right to inherit. So people still may want to be separated from their spouse, but have their spouse inherit. So as you can see, the family law encompasses many different aspects and topics. So it's a very broad term. And what's interesting is the word family really hits home for me because my dad has been practicing family law for over 50 years. So while we've never worked together, it's a business that's in the family, but not a family business, if that makes sense.
What's that like, having your dad be a role model and for you to follow in his footsteps, but to have your own business? I imagine your father's very good at what he does and has built a practice. Do you ever feel like you're in a shadow?
That's an excellent question. The simple answer is no. And that's partly why I started my own practice, is because I wanted, as you know, we don't control who we're related to, and what our name is. So I thought that by starting my own practice, I would be able to get the benefit of having a reputable name in the industry, but still be perceived as having the courage and fortitude to start my own business. Strike out on your own, as they say.
Yeah.
So having my dad in the business is really amazing because I have a built-in lifeline, so to speak. If a case gets hairy and I don't know what exactly to do at that point.
Yeah. You have a confidant.
I have a confidant, and I can pick up the phone and call him, and he loves nothing more than to talk shop, especially in that situation. So I really have the best of both worlds because I don't have the oversight of having, I don't have to have the pressure and all the unique experiences that come with working at a family business. And the dynamics that are involved and the politics that are involved. But I do have a confidant and a mentor who I can call at the drop of a dime.
When someone puts together a premarital agreement, what does that look like? What are some of the elements of prenuptial?
So oftentimes people who enter into premarital agreements have already been married once before, or they have a substantial non-marital estate. And when I say non-marital, that means assets that were accumulated or acquired before they get married. So oftentimes they will protect, they will specifically reference an asset or a series of assets, an investment account, a piece of real estate, what have you. And they just want to, so assets is one aspect of the prenuptial agreement. Liabilities is another. I mean, somebody can own a business and have several different loans with financial institutions that they want to insulate their new spouse from.
Oh, that's smart. So they're doing it to protect their spouse.
Yes, creditor protection.
Okay.
Or to protect themselves. They've inherited a bunch of money, and they want to use that inheritance to supplement their lifestyle. But in the event of a divorce, they don't want their entire inheritance to be deemed to be marital because they've used it for a marital purpose. So it really
that's
helps.
one of the most common ones I've seen with friends of mine.
Absolutely.
They have inheritance or they have a trust, and it has to be outlined to understand what is there and what isn't.
Sure, and it helps really segregate and earmark certain assets from being grouped into the marital pot. Another reason is we briefly discussed child support. Well, there's two types of family support. There's child support, which is when somebody pays a when one parent pays a sum certain each month to the other parent to help support a child. But there's also spousal support, which is formerly known as alimony and also known as maintenance. So a prenuptial agreement can absolutely cut off one spouse's right to maintenance. And instead of having a court decide in the event of a divorce, you basically nip the issue in the bud, and you enter into a contract where one person waives their right to maintenance from the other person. That's very common.
When you do this, both parties have to be represented. Is that right?
That's actually not true.
Okay.
That's a common perception. So, neither party has to be represented. What cannot happen is one lawyer cannot represent two people.
Okay.
So that's a conflict of interest. So oftentimes, one of the spouses, the moneyed spouse with more assets, the one who wants the agreement to be executed, will be the one who hires a lawyer to prepare it. So it's good practice for the other side to have an attorney, but it's not legally required. And the state of Illinois is very favorable in terms of upholding prenuptial agreements. So unless there's some sort of traditional contract defense like incapacity, fraud, duress, coercion, here, then courts will honor it. But you can be literally on the altar, or the day before the wedding at the rehearsal dinner, and say to your fiance, sign this or I'm not marrying you.
That seems like duress.
It seems like duress, but the law says you don't have to sign that agreement.
How often is that stance given, or that when someone 10 years down the line they get divorced, someone's like, he did this on our wedding day?
Very often.
That defense is used?
Very often that defense is used, but it's almost never upheld, because the court will say, you didn't have to get married. And I'm not saying I agree with that, or I think that outlook is fair. It just goes to show that it's good practice to have these conversations well before the wedding, well before the rehearsal dinner, so everyone can make adequate preparations.
If the other party isn't represented, do they have a similar defense of, I didn't know what I was doing, I wasn't represented?
No.
Okay.
I mean, no one is required to hire an attorney. It's sort of a similar concept as being pro se in a divorce. What I recently found out, a statistic that blew my mind, is that 95% of people getting divorced in Cook County are unrepresented.
And is that then, what's it called when you dissolve a marriage? Is it dissolution?
Yes, dissolution.
So when someone does that, is that what that is?
Dissolution just means, divorce and dissolution are the same thing.
Okay.
So most people either can't afford a lawyer or have very straightforward estates.
I imagine they have nothing to argue about.
That's right.
Right.
That's right. So there's something called joint simplified divorces if you're married under 8 years and have an estate with a combined total of less than $50,000. But if one person has a lawyer and the other person's representing themselves, it's called pro se.
Mm-hmm.
But pro se litigants are treated by the court as attorneys. I mean, courts give them every opportunity to hire a lawyer. But if I just had this issue this morning where I was in court. I'm representing the husband. The wife has been through 2 lawyers already. She fired both of her lawyers.
Why does something like that happen?
People, for either financial reasons, somebody owes their attorney money, or the other option is some clients are just unrepresentable. There's irreconcilable differences between attorney and client. You don't agree on the theory of the case.
Okay.
The lawyer can fire the client can fire the lawyer, so nobody's really bound. Nobody's forced to represent anyone else. But when that happens, just because somebody is representing themselves doesn't mean that the court's not going to treat them as if they're represented. So in this case I was talking about this morning, she's had 30 days to hire a lawyer. She didn't do it. The judge gave her another 30 days, so now it's been 60 days. And at a certain point in time, we have to proceed, either proceed without her or treat her like she has a lawyer. because she's had every opportunity to hire a lawyer. She's just made a conscious choice not to.
How long will that judge push that out? How much extra time will she get?
Judges are generally lenient, so in family law what's interesting is we have no juries. So the judge who's wearing the robe has all the power. By law it's 21 days, but judges have a lot of discretion to do what they think is fair. And in that situation, I expect the judge to probably give her another 30 days.
Okay. I've definitely seen that with evictions and in real estate. Someone will say, oh, I got injured, or this happened, and all of a sudden, okay, 3 months added,
Right.
30 days added, sometimes even greater periods if the reason's large enough.
So you can see how the system may be prone to abuse or manipulation to a certain extent.
Manipulation, for sure.
Because people can get the benefit of that extra time.
And now everything's transparent, so they just went on a few forums, read how to do this.
That's right.
And they push it forward.
That's right. I want a continuance. I want to speak to a lawyer. So because everyone in the Constitution, we're entitled to effective assistance of counsel, people think that they can get continuances to the end of time, when that's not necessarily the case. At a certain point, you got to, do your business or get off the pot, as they say.
If someone is heavier, I don't mean by weight, but in terms of their resources, and the other person is not, does the judge ever look at that and lean and give this person more leniency who has fewer resources than the person who does?
Absolutely. So the intent of the court is to administer justice and do what's equitable. Now, equitable doesn't necessarily mean equal, it just means fair. So yes, anytime individuals, anytime there's a pending lawsuit and you're in the court system, courts have jurisdiction to do what's fair. So if they perceive that one person is outmaneuvering another person because they have more resources, judges are going to do what's called level the playing field. So the classic example is, there's a very shrewd businessman who, hires a high-powered firm to just, paper, to try to, we call it papering to death, to try to out-litigate their spouse who has fewer access to resources.
I've seen this in movies and other things.
Absolutely.
Yeah, the drop-off boxes.
That's right.
Paper.
So what judges do is they make sure that everyone has adequate access to resources, and in that situation, a judge may order the individual with more resources to pay the attorney's fees of the individual without resources.
Why would that happen?
To level the playing field and make sure that one spouse cannot cut off the other spouse financially, so that they can essentially defend themselves and defend, secure what's rightfully theirs. So the legal system is set up to protect individuals, not reward people for, engaging in conduct that's intended to get the upper hand.
So if the judge sees this, he's going to use his own judgment to decide, okay, this person, I know what this person's doing. Let's make it fair for the other party
That's right.
involved.
That's
Okay.
right.
Now, it used to be alimony. Now it's maintenance. It used to be divorce attorney. Now it's family law. Why do these things change? What is the difference between alimony and maintenance other than the term?
It's a great question. So the term alimony, maintenance, spousal support are all synonymous. Things are constantly changing. Vocabularies are constantly changing. In the law, that's one amazing thing about the law. So I don't know why some people call it alimony, why some people call it spousal support. You used to be able to get a tax deduction for alimony, so I think it was referenced in the IRS code as alimony. I think it was called alimony because in the Internal Revenue Code, you were able to, that was the correct verbiage.
That's the term they used. And so
Right.
if you can use that in your legal case, then the IRS is not going to be able to dispute you deducting it.
Precisely.
Can you still deduct alimony?
You can no longer deduct it if you get divorced after 2017, which is when they changed the law. However, if your agreement says, the person who's paying it gets the tax deduction, and the person who's receiving it has to declare it as income. If that's what the agreement says, then courts will grandfather those cases in. But if you're getting divorced today, then one spouse has to pay the other spouse spousal support or maintenance or alimony. I'm using these all interchangeably. It is not deductible by the person who pays it or includable in the gross income of the person who receives it. So that really made it difficult because that was a huge bargaining chip in negotiations.
So if, to understand this correctly, it's grandfathered in prior to 2017, but if you put it into a prenuptial agreement post-2017, you can have it as...
No. That's a
there's
great
no way
question.
to do it.
If you put in a prenuptial agreement, no. But what you can say is, if you got divorced before 2017 and one spouse needs to modify it because they're making less money or they're making more money, then you can do it that way.
Something like maintenance, how is that determined?
It's determined by there's 12 different factors in Illinois that the court uses, and it's really a balancing test. You look at the age of the parties, you look at the income of the parties, you look at the health of the parties, you look at the length of the marriage. So if people are married for 9 months, it's going to be very tough for one spouse worked during that 9 months and the other person did not. It's going to be very difficult to say you're a maintenance candidate because it's such a short-term marriage. There's now, back in the day, there used to be 12 factors, and a judge didn't have to give any weight to any one of those. Any particular one. It was just kind of, whatever the judge felt on that day. Now we know how long it is because there's a formula based on the length of the marriage.
There's always a formula?
There's always a formula based on the length of the marriage and the amount of income.
Okay. And before it was more discretionary by the judge?
It was all discretionary.
When did that change?
That changed, I want to say, within the last 10 years.
Okay.
And the same thing happened for child support. So child support used to just be a straight percentage. If you have one child, you pay 20% of your net income. It was a very specific definition of what net income was. If you had 2 kids, you'd pay 28%. If you had 3 kids, 32%. Now, Illinois is what's called a shared income state. So you take mom's income, you overlay it with dad's income, you then, I plug it in a formula, and depending on how many overnights each parent has, the formula spits out a number. So if one parent has 146 overnights out of 365, that's considered 40% of the time. That's shared parenting, which greatly reduces the child support number.
So it seems fair to the spouse who's making more, maybe, if the other person still has a good salary. If someone's making 300 and someone's making 150, it's going to be more favorable for the person who's making the 300, not more favorable, but fairer to the person making the 300 as opposed to the past. The 150 wouldn't even been taken into consideration.
Exactly right.
Okay.
That's exactly right. So now, in that, using your example, the person who's making 150, that gets factored in the calculations. And the formula even goes as far as to basically separate out what each parent's respective obligation is based on their income. So it's really taken a lot of guesswork out of the situation, but like anything else in the law, it's open to interpretation.
I imagine that makes your job easier, but also reduces your time.
That's right.
So that's a good thing.
It does make my job easier, although when one parent makes $175,000 and another parent makes $125,000 and they have equal time with their kid, the law says in that situation the person who makes $175,000 only has to pay $300 per month or $10 a day in child support. So it costs a lot more than $10 a day to support a child.
Yeah.
So you can understand how this can create issues.
It's a great point coming down to money. How do you charge for this?
So the way I work is hourly. I take a retainer generally, and the retainer, the amount of the retainer is commensurate with the complexity of the case. So if somebody comes into my office and during the first interview, I have a pretty good ability to discern whether a case is going to be contested or not. So if somebody comes into my office and I know that there's going to be contested custody issues, we now call it allocation of parental responsibility.
Okay.
It used to be called custody. And
There's another change.
there's another change, right?
Is there, what is it again? Allocation?
Allocation of parental responsibility.
Allocation of parental responsibility.
We
Is there
used
a
to call
reason
it
that changed?
custody, not the law change, the statute changed. So, every 5-10 years, the Illinois legislature meets downstate in Springfield, Illinois, and they make these sweeping changes that change the way everyone's been doing things.
And is that to stay up to date with how the world is evolving?
Partially, yes, and it's to take into consideration trends in society. I mean, now, when I first started practicing 13 years ago, dads would come into my office and expect to see their children every other weekend, and maybe one dinner a week. Now, 50-50 custody or 50-50 parenting time and joint custody is the starting point.
Okay.
So-
I'm a product of two parents who were separated, and I saw one parent one day a week for dinner, and then every other weekend. And so now the beginning is completely equitable from the start.
Yes.
Okay.
Yes, so the starting point is equal parenting time, whether that means 1 week on, 1 week off.
It seems so disruptive to children.
I totally agree. I totally agree with you. And courts generally like more continuous periods of time with less exchanges. So it doesn't make sense for a child to be with mom Monday, dad Tuesday, mom Wednesday, dad Thursday. That's too choppy. So what courts say is let's do longer period, less exchanges, so mom and dad don't have to see each other as much, and more quality time. So perhaps a week on, a week off, or Monday, Tuesday, mom, Wednesday, Thursday, dad, and we alternate weekends. So it has opened up the need to be more creative with our scheduling.
I feel like I've seen, from being a child and being in parents that work together and seeing other families that were the same way, nowadays I feel I see many more parents living in the same areas because of that. And I wonder if that's part of the reason why, because that's changed. So like, okay, you live in Barrington, I'm going to live in Barrington. We're both going to live here. So
Certainly.
Yeah.
Certainly. And I'm glad you're bringing this up. And it's hard for me to remember the exact year, but within the last 5 years, the Illinois legislature also passed what's called a radius clause. So not one parent can't live more than 25 miles away from the other parent.
One of my clients
without
just
a
went
court
through
order.
this and was telling me about this. So what does that mean?
It means, what's so crazy about this, Johnny, is, if one parent, it means that you have to be, if you're going through a divorce or a separation, you have to actually measure the mileage. So I had a case where dad lives in Chicago, mom moved to Bolingbrook, so she lived like 25.8 miles away from dad's house, and mom had to move. The court said that mom had to move. So you can have a situation.
Why is that?
Just because now, as a result of there being more equitable parenting schedules, we don't want children in the car during parenting time exchanges. If two parents live 20 miles away, that's an hour each way that the child's in the car instead of studying, engaging in extracurricular activity.
I dealt with that as a child. My mom never lived within an hour, but that would be that's not fair to the other parent, I think.
That's right.
Because what if you don't have the resources to live in that radius?
Right. You can understand how sometimes laws create more problems for people than solve these problems.
But I do understand the court's point of, okay, we don't want the child to be this ball back and forth with parents.
You don't want to be ping-ponging a child
Yeah.
back and forth constantly. But it's, children more often than not adapt, or parents come up with plans. That's all the more reason to have longer periods of time. Because if you can have a child in the car once per week as opposed to 3 times per week,
I can't even imagine how parents would do that if they don't live in the same school district.
It makes it very difficult. It makes it very difficult.
How do two spouses or a spouse broach this topic of a prenuptial agreement with their spouse without losing all the romanticism that marriage is supposed to be about?
It's an excellent question, and there's really no legal answer to that. I mean, the way that I view a prenuptial agreement is no different than a life insurance policy. So while it's perfectly understandable if you're engaged and excited to be with your life partner, the last thing you want to think about is what happens if it doesn't work out. But no one ever says to themselves,
What if I don't die?
Right. What if I don't die? So you're just planning for an eventuality that may or may not arise for the future. So it's really transactional in nature, and this is why a lot of people don't enter into prenuptial agreements, or why some people downright refuse to sign them. And if somebody wants to get married, they still proceed.
How often do you hear about that? Someone saying no.
I've never had a wedding fall through as a result of this, as a result of the terms of the prenuptial agreement. I've been pretty darn close, and I actually recently I was representing someone who was supposed to get married in November. We hit a snag in our negotiations, and we were at an impasse in our negotiation of a prenuptial agreement. And
Are you dealing with another attorney?
I was dealing with another attorney, and then I just didn't hear from my client for 6 months, so I assumed that the engagement was broken off. Well, lo and behold, just last month I got a call, and the wedding, they just continued their wedding for 6 months, and we were able to get it done, and they're married.
What's the difference between eloping and getting married?
So eloping is when you get married, you just don't send out the formal notice. There's no wedding invitation. There's still there still has to be an officiant to make it legally significant, but there's generally an abbreviated engagement period, and the law treats a couple that elopes the same way as a couple who gets married, with plans. It's just kind of a clandestine marriage or under the radar marriage, which leads me to the next topic, which is annulment. People worry, what is the difference between marriage and annulment? So a marriage is valid, meaning that two people were legally eligible to get married. An annulment is that one person didn't know they weren't divorced from someone else. So, or so it's the marriage is invalid for a reason because it never legally took place.
How often do you deal with that?
Once in my career.
Only once?
Only once. And believe it or not, I've only had one come across my desk, and that was one person thought they were divorced because they were separated from their spouse for like 13 or 14 years in a different state, and they ended up having to get divorced. And it wasn't an issue, but they had to get divorced in Texas or Louisiana, and then they were able to get married in Illinois. So we had to do, so what happened is they got married in Illinois, we then had to annul it, and then they got remarried.
Okay. I've heard of varying laws for prenuptial agreements and divorce based on what state you're in. How does that work? Is it about where you got married? Is it about, how does that work?
That's an excellent question. So it's where you get married does not control. It's whatever state's laws you want to control. So
is that where you're living, or how's that defined?
One person has to live in Illinois for at least 90 days. In order to get divorced, you have to live in Illinois for 90 days, before the court enters a judgment of dissolution of marriage. So you really have to be a resident of Illinois. So one person, there generally has to be close contacts to Illinois. So one person works here, they own real estate here, but people can get married in New Hampshire and say that they want Illinois laws to control because Illinois laws are more favorable. That's called a forum selection clause. Some people get married in Illinois and they want Texas law to control because Texas is not as liberal when it comes to spousal support. So it's more often than not, it's the law, it's the state of the law where the people live.
How do people gain that? We're talking about people with resources. I can imagine if I had an enormous estate and I want a particular state's laws because I think it's going to be more favorable for me, I'm going to go move to that state.
Sure. It's sort of, it reminds me of when people, have offshore accounts.
Mm-hmm.
They just kind of, align themselves with educated individuals, trusted advisors, financial people, attorneys, who can advise them as to where it makes the most sense. So just as you would consult with a financial planner, to open an offshore account for more favorable tax treatment, same, you can consult with a lawyer. You don't have to live in a state to consult with a lawyer in a different state. But you do have, the attorney has to be licensed in that state. So I'm only licensed in Illinois. So I cannot draft a prenuptial agreement where Michigan is the jurisdiction. I'm only licensed to practice law in Illinois.
Interesting. So if you do the prenup here and someone else gets divorced elsewhere, is that prenuptial agreement valid?
Generally, the prenuptial agreement will specify which state has jurisdiction. So it's good practice to sort of eliminate that right off the bat so you're not running into these jurisdictional hurdles.
Okay, so when you're drafting the prenup, you remove what venue it needs to be in, and it's blanketing?
Or you specifically specify which venue it will,
depending how you're
to eliminate any ambiguity. Can we?
Yeah, absolutely.
I just have to.
A lot of people, I think there's going to be a number of people that paid too much and they might be under the burden of that home for an extended period of time, more so than they ever thought.
Interesting.
But it just depends, because if rates go back up, prices will come down, and people are going to be stuck in these homes worth more than the current value will be. At the same time, I don't know, because there's been all these suburbs that have never had these price increases, arguably should have.
Like what?
All the fringe, all the
Oak Park. Or
no, not like Oak Park, further west, or a place like Melrose Park.
Okay. Or you don't just stay in the city, do you?
I do primarily.
Okay.
Yeah. So I have a good network outside of the city, and I don't even own a car, but it's more so that when I'm working outside of the city, it's with people that trust me. They want to work with me. It's important to them that I'm working on it. If that's the case, yes. So it's case by case, but more so it's like let the expert in Oak Park do the Oak Park deal.
Totally. No, that makes a lot. I mean, it's the same thing for law for
Yes.
me. It's like sometimes I'll get a call for a case downstate, or even in like Will or DuPage County, where it's amazing the cultural differences.
Yes.
And if you
I run into that's part of it too.
Right, and if if these judges don't, and I practice primarily in Cook County, where the judges, I see the same judges, they know my face, they know my personality, they know if I say something, I'm telling the truth, whereas, the term home court advantage is actually not a sports term. It's really, the way I interpret it, it's really references to the law, where a big city attorney comes to a small town and just gets railroaded by the judge or opposing counsel. So it's always in situations. I had a case of a very large marital estate. It's important to know the cast of characters wherever you're practicing. So I had a case many years ago where there was a very sizable marital estate because an individual was permanently disabled and he was in a terrible accident, received a huge settlement, and he lived in Peoria, and I had never been to Peoria. He was getting divorced. I had never been to Peoria. I had never appeared in front of a judge in Peoria, and I just didn't know how things worked down there. So I did my homework. I called, the number 2 guy down there. Of course, my client's wife hired the number 1 guy down there. And we just co-counseled, and basically it was almost like a Wizard of Oz situation. I was the one, direct calling the shots and pulling the strings from Chicago, but in terms of, appearing in court every day, interacting with opposing counsel, I had, my co-counsel or local counsel handle those because he had this close relationship with my opposing counsel by virtue of just, being in a one-horse town. Yes.
Yeah. Well, and I imagine your client, or this joint client, he got 2 for 1.
Right.
Right? It's only a benefit to him. He has 2 people.
That's right. The only downside is you have to pay 2 lawyers in that situation, but...
So it wasn't working as a referral, for instance. You're still involved, so you're still getting...
That's right.
Okay.
It was a co-counseling situation, which I do fairly often. I mean,
Why would you do that?
I'm a one-man operation, so
Mhm.
if a case is particularly complicated, or there's hundreds of exhibits because somebody owns, a business, or has some complex financial situation, or you have a lot of exhibits that need to be introduced into evidence, because there's a custody trial. There's just too much work to do.
Yeah.
So sometimes because I am a more boutique operation, I'll enlist the assistance of one of my colleagues and pick up the phone, and it can be fun to kind of delegate the duties, and it takes the burden off one individual to have to try the whole case. And 2 heads are better than 1.
Mhm.
So it's nice because I don't have a partner. The individual I bring in as outside counsel will effectively act as my partner for that matter only.
And they're going to have a different perspective because they're not with you day to day. They're just going to
That's
have
right.
a different viewpoint.
That's right.
I've heard of people, you mentioned the first and the second best attorney. I've heard of someone interviewing multiple attorneys in order to reduce that list down so their spouse has fewer options available.
It's called the Tony Soprano.
Okay.
Back, I don't know if you remember the Sopranos.
That's
which is
exactly
a-
where I just pulled that from.
Which is a series on HBO, and believe it or not, it happens. So when one individual, a law firm, if a wife goes to see a law firm where a husband's already done a consultation, that's a conflict of interest. So oftentimes, in a contentious case, out of gamesmanship or to get a leg up in the litigation or disqualify certain attorneys from representing your spouse, one person will meet with as many lawyers as they can for that purpose. More often than not, lawyers charge for a consultation, so it can get expensive if you're meeting with 10 lawyers and paying
Okay.
that 10 lawyers hourly rate, but it can be a drop in the bucket for multi-million-dollar estates or even billion-dollar estates.
I'm glad you brought that up. When you mentioned the interview before, so when someone wants to meet with you, you pay for that initial consultation?
Yes, so
How
generally,
does that work?
So more often than not, I charge for an initial consultation. I mean, Abraham Lincoln once said that a lawyer's inventory is his time.
Mhm.
So really, all we have to sell is our legal services and our time. So it's also a really good way to
Weed people out.
to weed people out.
100%.
That's right. So if somebody sort of balks at the consultation, or that they're shopping, or has to think about it, they're shopping around, because what happens when it's time to pay your bill after 10 hours of legal time, if they're not willing to pay that consultation fee, more often than not, they're going to not want to pay their invoice when it comes around. But it's also a way for the lawyer to interview the client as well. I've met with individuals who I just perceive it's not going to be the right fit.
Mhm.
They want something, their expectations are unreasonable, or they wish to take a position that I don't believe is in good faith. So I don't want to be part of. I don't want to have my name as an attorney appear on a document or a series of documents that are intended to antagonize the other party.
Mhm.
There's plenty of lawyers who will just do anything their client wants them to do, but I am not one of them. So I've had to fire plenty of clients because we don't see eye to eye, or they want the case to proceed a certain way and I don't want to, or vice versa. So no one is stuck with their lawyer, except on the eve of trial if somebody tries to fire their lawyer to get a continuance. Judges are on to that.
Okay. I don't have the same privilege that you do in terms of being able to charge for a consultation, but everything you just said, I can relate it to real estate 100%. It could be an unreasonable price for a home or an unreasonable price for a purchase. Like, this is never going to go anywhere. Why would I take this listing? Why would I waste my time on it?
And a client insists on it being
Yes.
the listing being above a certain amount,
Mhm.
and you say, well, if that happens, we're going to, unless we're under a certain number, we're going to lose a lot of.
We're going to lose the time, we're going to lose the opportunity. So this year has been a perfect example, because if you listed 6 months ago, you're going to do better than if you list today. Simple as that. And the prices you could get 6 months ago are not going to be the same that you can get today. And now if you're a buyer, you're going to be in a stronger position right now. Well, some people are still looking 6 months back, and they only want to focus on that. And they're going to say, okay, well, I want that number. That's great. I can't do it for you.
Right.
And I'm not going to spin my wheels trying to do it.
And it's almost like a first date in a way.
Mhm.
I mean, you can glean a lot from that individual.
Yes. Well, I have people that reach out to me, and I just happened last night. And I'm responding to someone, I respond very quickly. Hey, I'd like to meet with you. And they're like, no, I just want to get your opinion via email. I'm like, and I literally wrote to them, like, I've found that people that won't take the time to talk to me over the phone will never end up being clients. If you change your mind, please let me know. And that's what it is. People just want to feel you out. They just want free information.
Right.
What's brain drain? They just want to get as much out of you as they can.
And I have that too. So by charging for a consultation, you really put value on your time, as well as prevent people, or if somebody is going to shop around, at least they're paying you to disqualify you in that case.
How long does that stay true? If someone is paying for your time, they do the consultation, and let's say they are trying to Tony Soprano someone, is there, what's the legal term for the time period?
Statute of
Is there a
limitations.
statute of limitations on that?
So the client can waive the conflict.
Okay.
So you can say, all right, I understand you met with your partner met with my wife, but I still want to use your firm because you're a brand name. So the conflict of interest is the client's to waive, or the client says, I understand, but I want you to represent me. So under that circumstance, the client can waive it.
Okay. What are things that people do to play dirty when it comes down to a divorce? Because you rarely hear about a positive divorce. I think in reality you do. I've known lots of people get divorced, and it's mostly amicable, and two people are not salty about it. But the media portrays divorces much differently.
Sure. Well, it's a wonderful question. I mean, there's an infinite amount of ways where people can play dirty or engage in gamesmanship or try to get a leg up in the litigation. But that's something that that's really where ethics and your moral compass comes in. So, I believe in practicing law the way I live my life. So I always try to take the high road. There's things that people can do that test the boundaries of the law that aren't necessarily illegal. Someone can. So it's a million different things. One of a classic example is if an individual owns a business. They run their personal expenses through the business. Unless you're going to audit somebody's tax return or take their deposition or hire a forensic accountant, it's hard to know whether a purchase made at Target was for a personal expense or a business expense. If it just says $100 credit card charge on Target or $1,000 credit card charge at Menards, you don't know if you can see how. So it really becomes discretionary on part of a lawyer or on part of a judge in that situation to know when someone's playing fair or not.
So that's a great point on those type of expenses and those type of things. If someone has to audit it, or you're bringing in third parties to confirm these things, the cost is coming from the client.
That's right.
So they have to gamble, and they have to know, they have to be confident in the ability to have success in this in order to outlay that money.
That's right. And if they get caught, then what a court can do is they can say, all right, well, you're only disclosing $100,000 on your tax return, but for purposes of setting child support or maintenance, since you use the business as your piggy bank, so a court can do what's called impute income. So they can find, based on someone's lifestyle or the fact that they don't have any debts, that their income is really closer to $250,000 a year. So income for IRS purposes, just because somebody reports income on their tax return does not mean that the court's going to take that at face value.
Okay.
So it's the skilled practitioner's job to sort of pick at that scab, add income back, and convince a judge that based on an individual's lifestyle that they have to extrapolate income.
Let's say spouse A knows spouse B makes way more, and maybe they're doing what you're suggesting right now. Spouse A wants the audit. The audits come back unfavorable for spouse B. Does spouse B then therefore have to pay those expenses? Because they basically were denying it. Then they find out they're a liar. In what case is spouse B paying
Spouse
that?
B can hire their own, is free to spend $10,000, $15,000, $20,000 on their own experts.
Oh, so they'll do that to dispute it.
They'll do their own expert to dispute it, and then, if they can't, then it becomes a battle of the experts, or you split the difference.
Okay.
Or my expert says your income's $150, your expert says your income's $300. What if we split the difference at $225? And for purposes of this agreement, only, base the deal on that. So, what this is exposing is, the lawyer's best friend is creativity. So, even though we have these laws, everything really falls in the gray area. So it's really up to the skilled practitioner to sort of engineer a deal that both sides are slightly dissatisfied with. That's how we measure if a deal is fair, or if both parties are unhappy with it.
I always say that. That's how you know it was a fair agreement,
Right.
And both people walk away unhappy.
That's right.
And then the half glass full person say, "What if they walk away happy?" I don't know. How often does that happen?
Right. Very.
Then
rare.
you weren't pushing enough, right?
Both people are miserable. It's a good deal.
What haven't we talked about? Is there anything important? What should someone expect when they meet with you?
What someone should expect when they meet with me is to, get the truth all the time. I'm as straight of a shooter as they come. So my job is not to tell people what they want to hear. It's to tell people what the law is and what their rights are pursuant to the law. So it's a series of very difficult conversations. Oftentimes, my job is to protect people from their own expectations as well as to protect them from injuring themselves. But really, if I were to enlighten somebody about what I do, it's what lawyers in general do is, the legal system is really set up to resolve disputes. So anytime you're going through a divorce and you have children, you're legally required to mediate. So, basically, judges will send you to mediation. There's a movement that's called alternative dispute resolution, where people basically agree not to litigate and, try to
So it's like
resolve
arbitration?
everything. Yeah, very similar.
Okay.
The only difference is in arbitration, the arbitrator who makes the decision makes a binding decision. In
Right.
mediation, it's not binding, so people are still free to change their mind and renege on a deal.
Okay. How often does that happen?
Not very often. Generally, if people are going to use the resources to go to mediation and pay both their lawyers and the mediator, who's often a retired judge.
Okay, so if you do mediation, you still have an attorney.
Yes, so
Okay,
you
got
don't
it.
have to. I mean, it can be attorney assisted or not. But oftentimes, some people like to have their attorney there so they won't agree to something without having an attorney present, or they just benefit from having the emotional support. because in family law, things such as money and children are such sensitive topics that hit so close to home. People like to bring a sibling, a parent, a friend, just for emotional support.
And the process can be debilitating. In the beginning, you mentioned you don't work in adoption, and then there was another term that I didn't know what you said.
Surrogacy.
Surrogacy. Okay.
Right. So it's oftentimes when there's a whole world of in vitro fertilization. Somebody, there will be a donor sperm or donor egg, so that one of the biological parents' genetic material is in controversy, or somebody can contract away. If you want to pay someone $10,000, to basically carry your baby for them, in their womb, and then comes time to give birth, and they say to themselves, "I actually want to keep the child." You can see how this can create a multitude of problems. So this is a cutting edge area of the law that is still gaining traction, and with the advent of technology,
It's only going to increase.
It's only going to increase. So it's something that that is so specialized that I just would rather refer it out to someone who exclusively practices in that niche.
I can imagine that. Just hearing you say it, it sounds so complex.
It is.
And I feel like you'd have to just do, you'd want to specialize in that in particular.
Right.
Is that the same for adoption?
Adoption, there's a lot of family lawyers, I would say at least 25 to 33% of family lawyers also practice adoption law. It's just, it's so specialized that while it does fall under the heading of family law, it's just more of a subspecialty.
I didn't know you didn't do it until today.
Yeah.
I always assumed you did. It's never come up.
I've never had it. I've never had it come across my desk, and if it did, I would refer it out to someone who has experience in that field.
As someone who's completely ignorant to it, what would be the difficulties or expectations that would cause an attorney to be involved in adoption?
Just my understanding of the adoption, there's just a process. In the legal system, one reason people have lawyers is because the legal system is so murky, and you just don't know where to start. So there's plenty of people who come to me that they already have reached an agreement on their own. They've decided they're going to get divorced. They've agreed on the terms. They just need someone to do it the right way.
To memorialize it, make sure it's correct. Okay.
So because adoption has to be, there's so many technicalities, and it has to be done the right way, and there's waiting periods and rights of revocation. It's best to really go to a specialist. There's the expression "jack of all trades, master of none." You want something done, go to an expert. The right way, go to the expert. You don't want to go to a heart surgeon for brain surgery. It's sort of the same concept. You want someone who just does these things all day long.
What's the timeline for, and I don't know if there is a typical prenuptial agreement, but is there, if someone wants to be prepared, how much time how long before they're going to get married should they take this into consideration and engage someone like yourself?
It's a great question. There's no timeline. There's no timeline, but it's because generally there's negotiation back and forth, generally because one person wants an opportunity to have an attorney review the terms to make sure that the agreement says what it purports to say. I would make sure that I would advise any individuals who want a prenup done to contact an attorney at least 30 days before the wedding date.
Okay. Is there anything that sparks a postnuptial agreement?
Not
We
really.
went over a few things, but is there anything that would really do it?
No, some stuff just happens. I mean, what comes to mind is I had a postnuptial agreement several years ago because I represented the wife. She found out that the husband had a 10-year-old son that she never told him about. So while
The spouse know?
This-
The spouse didn't know.
the spouse did know, he just never told his fiance that he had a son from a different relationship. So she felt like that was a violation of trust, and
That's
so she-
the highest tier of
so-
violation.
Right,
of
so she
trust.
said, before we get married, I want you to enter into a I'm sorry, they were already married.
Mhm.
So she said, I'm going to divorce you unless you enter into a postnuptial agreement, because she had just purchased a house. So she
Okay.
didn't want, so she would, and she made the down payment entirely out of her premarital money. So she just wanted to make sure that in the event of a divorce, that her husband wouldn't make a claim to this house. Well, what ended up happening, she could never get over the fact that he didn't tell her he had
Yeah.
a son. So it ended up being a twofer. So I represented her in a postnup, and about a year later, they got divorced.
Wow. Let's end on that. Thanks for doing this, Sean.
Of course, thank
We
you.
appreciate it. This is really
Great.
illuminating, and you never know how these are going to go until you sit down
Right,
and start
that's right.
talking. But it's engaging. There's so many different avenues this can go down, and so
Absolutely.
much information. And it's very clear why, if you're thinking about getting divorced and you have assets, you have particular things you may need to protect or memorialize and make a fact that
Right.
you have them. It's important to engage
Well,
you.
just get a lawyer, because, you know, the courts will say you should have gotten a lawyer. It's really not an excuse I didn't have a lawyer.
Yeah. Okay. Thanks.
All right, thank you so
Yeah.
much. Great to see you.
Likewise.